Good morning and welcome. And I'm Sandra with Ethra's Public Guardianship for the Elderly Program, and I wanted to introduce our speakers today. First with us, we have Bill Reeves, who's a local attorney. He's an experienced and qualified litigation and business attorney whose practice areas include trials and alternate dispute resolution cases in state and federal court. He maintains membership here at the Tennessee Bar Association, the Knoxville Bar Association, and the Hamilton-Burnett end of court. Lynette Edwards is an attorney with Ethra and the East Tennessee AAAD Public Guardianship Program. She covers 16 counties in East Tennessee and has been the public guardian since 2017 under Ethra and ETAC. Lynette is a Rule 31 civil mediator and has a passion for working with the elderly. She is a national certified guardian and maintains memberships in the Conservatorship Association of Tennessee, the Tennessee Bar Association, the Knoxville Bar Association, and Tennessee Association of Professional Mediators. And also with us is Ryan Hicks. He is the Senior Associate General Counsel and State Public Guardian Coordinator for the Tennessee Commission on Aging and Disability. And in these roles, he advises the agency on legal issues as they arise, oversees agency contracts, and administers the public guardianship for the elderly program. So let us welcome our speakers today. Thank you for being here.
Good morning. Before we get started, we were going to see who all we're talking to this morning. Like, how many people are in here from law enforcement? Okay. And how many attorneys are there? What about people that might encompass the rest of you that work in the social work arena or the AAAD, aging? That's everybody else. Okay. And some conservators. Are there conservators? Okay. Oh, wow. All right. Good. Well, so what we did, we're basing this program on a list of questions we got, like our most asked questions about conservatorships and the public guardianship program. So we're going to use that as our outline, those questions. And we're mainly going to ask the questions and Bill Reeves, our expert, answer them. And Ryan is going to come in with the Tennessee Commission on Aging and Disabilities role in conservatorships and the public guardianship program after that. So to get started, because I don't know what everyone's level of knowledge is to start with, a conservatorship, you probably know, is the legal process by which a court appoints someone to make financial and medical decisions. And so we're just going to review all the elements, the basic elements and the laws that go along with conservatorship and the common questions. So the first one I get most often is, what's the difference between conservatorships and a power of attorney, a conservatorship and a power of attorney? And Bill, along with that, people want to know what alternatives are to a conservatorship, which would be a power of attorney, of course, but there are others as well.
Let's start with the power of attorney concept, realizing it's a formal process, but it doesn't involve a court. It's a contractual relationship created by a document, typically prepared by an attorney. A lot of times now you see them taken offline and simply signed. But it involves a person called a principal appointing someone called an attorney in fact to do things for them. And because it's a contract, it can be as specific, as limited, or as broad as wanted. A general business power of attorney typically authorizes the attorney in fact to do anything and everything for the principal. Specific things would be signing checks, signing deeds, making financial decisions, transferring funds, selling real estate. It's as broad as you want to make it. And the general business power of attorney is normally that broad. There is also a statutory provision for healthcare power of attorney to specifically authorize the attorney, in fact, to make medical decisions. And that's typically a different document, always a different document, than the business or personal power of attorney. It can be very limited. If, for example, a husband and wife are selling their home and the husband has to travel out of town on the date of the closing, if there is a date of closing, and can't be there to sign the deed, he can sign a power of attorney to his wife to sign for him. It can only be for that very limited purpose. The disadvantage, I would say, to power of attorney is there is no oversight. There's no bond. There's no court reviewing it. There's no one in place to make sure that the attorney, in fact, is acting properly in the best interest, always, of the principal. The attorney, in fact, is a fiduciary, and that means required by law to exercise only the best judgment and act in the best interest of the principal. But if you haven't seen it, it's out there. The temptation to self-deal is always present. So if you're going to do a power of attorney, you need to be sure that the person you appoint is trustworthy. Now, the conservatorship is a completely different concept. It's a formal court proceeding requiring very specific pleadings. I would think it's safe to say almost always requiring an attorney to assist in the process. It involves the court. It's basically a lawsuit where a petitioner, who can be anyone, calls to the attention of the court through a written petition that another person needs help, that they're unable to protect themselves either medically or personally or financially. And that process, they're typically filed, it's not required, but they're typically filed in the chancery courts, can also be filed in probate court or in circuit court. But typically, and as a matter of practice, most attorneys choose chancery court because the chancellors seem to be more familiar with conservatorship requirements. When that petition is filed, a couple of things happen. Immediately, a guardian ad litem is appointed. That's another attorney who is charged specifically by the statute with investigating the circumstances alleged in the petition, finding out if the person actually needs a conservator, finding out what their assets are, finding out also, very importantly, if the person filing the petition requesting to be the conservator is appropriate. So that investigation happens very quickly, and a good guardian ad litem will thoroughly investigate and then prepare and file a written report with the court. The guardian ad litem is not a representative of the person being considered for the conservatorship. The guardian ad litem is a friend of the court, is independent of all the parties, and is there simply to advise the court, kind of as just the long arm of the court, as what should be done, or their opinion at least, of what should be done. The conservatorship filing is very formal and very time and frankly expense intensive. It's not a cheap process because you already see you've got an attorney preparing the petition, you've got an attorney being appointed to investigate, and typically if the person objects to the conservatorship, you're going to have a third attorney involved called an attorney ad litem who does represent the best interest and the wishes of the respondent. The person being considered for a conservator is called respondent or ward, and they have the right always to object, to cross-examine witnesses, to participate as to the fullest extent that they can. Another important feature of it that's critical, and the Court of Appeals has recently emphasized how critical it is a sworn medical report from a doctor who has examined the respondent within 90 days of the petition. And what the Court of Appeals just recently ruled is that if the person objects to that sworn medical report, then the petitioner must put on real evidence at the hearing to prove the disability or the need for a conservator. So there are two very different approaches to trying to solve the same problem, that is to give assistance to someone who needs it. So that's just a quick, broad overview of the two concepts and the differences.
Good, and you just answered our next question, which is what does the conservatorship process look like? So that was the process. And as far as the other question about what are some alternatives, because we try to keep people from having a conservator as long as we can. That's, you know, we don't easily take people's rights away from them quickly or easily. So a couple of things are, you know, the power of attorney is a good alternative, the healthcare advance directives, healthcare power of attorney. And I don't know if many of you know about the post form. That one is kind of a healthcare directive, but it's done through, it's a document containing medical instructions for healthcare professionals. We do a lot of them at the Public Guardian Office to honor a patient's treatment preferences, CPR, breathing tubes, feeding tubes, and it becomes effective once a doctor signs it. It's actually an order, a medical order. And the next question, Bill, would be what powers does a conservator have? And I think you're going to say basically whatever the judge puts in the order.
Exactly. The typical conservatorship order, and I say typical by meaning the one we see the most as a result, would be very broad. Would include decision-making for personal matters, medical matters, and financial matters. But the form we have evolved and developed, and we sort of maintain and share these forms with folks who may not be thoroughly familiar with it, would cover everything that the person needs done. Access to their bank accounts, their brokerage accounts, filing their tax returns, making medical decisions, deciding where they live, what level of care they may need, whether they can stay in their home, whether they've got to move to assisted living or on up the ladder of care. All of those decisions can be covered in the order of conservatorship, but they have to be, because the statute's very clear that the court has to be specific about the authority that it removes. What you're doing is you're taking away the rights of an individual and giving those rights, that decision-making authority, to the conservator. And that leaves the person, the respondent, without the ability legally to make any of those decisions. And again, that's a distinction to think about with power of attorney. The person granting a power of attorney doesn't lose the right to make decisions by that. It's like a dual thing. And the principal in a power of attorney situation always retains the right to revoke that power of attorney. But in a conservatorship, they don't. If another way to think about it, if a person's put into say they're a drug abuser or an alcoholic, where they've descended into a hole they simply can't function in, well, they get put in a conservatorship. They're in a program. Their health improves. Their ability to make decisions improves. Then at that point, you look at whether or not the conservatorship should be terminated, and the respondent always retains the legal right to ask the court to terminate it. The conservator has a duty, upon seeing that, to advise the court that it appears this person has recovered, so that the conservator is no longer necessary. They're able to function on their own. Now, that doesn't happen with Alzheimer's, serious dementia, because it's basically irreversible. But there are cases where other causes are in play where it's reversible. So the powers that the court grants. Remember, this is always a three-party situation with a conservatorship. The court is always involved. The court never leaves the scene, and the court is always there to answer questions or respond. If the conservator has a question about what to do, for example, say the respondent has moved to assisted living, has a house sitting vacant with taxes and insurance and maintenance and, kind of an attractive vacant property, then the conservator may go to the court by written motion and say, we believe that it's time to sell the house because the respondent is never going to be able to move back there. They now need or will need the funds to pay for their care. But that again is a very formal court process requiring written motion, notice to the respondent, a hearing to authorize the conservator to basically market the property, whether by listing with a realtor or accepting a private offer from a family member or auction or whatever. And then once that offer to buy the real property is made, the conservator has to go back to court, again by motion and hearing, to have the court confirm that the sale should be approved. That's a safeguard so that the property doesn't get sold too quickly or too cheaply. And that's just further example of the authority that a conservator has, but it's not absolute. It's always dependent upon a process where the respondent, if they want to object and if they can object, has that right to object. So I hope that covered. I kind of forgot the question.
And I wanted to add too, when we're talking about putting things in the order to empower us to do things, for years it was just implied that we were able to make burial arrangements and funeral arrangements and even approve cremations. But then in the last few years, we started getting a little pushback from the funeral homes about that, especially about cremations. So we started putting language in about that to specifically grant us authority to do that. It seems like there are a couple other things that we put in specifically, maybe setting up. But we would strengthen our language about banking. And do we get a separate order all the time to set up a qualified income trust for Medicaid, or do we put that in the order?
That can be put in the initial order if you know you will need it, or you can do a separate motion in order.
Yeah. Okay. So we keep discovering little things we need to put in the order to make it bulletproof. That's true. Because in Tennessee, we have, what do they call it? The least restrictive alternatives. Yeah, least restrictive, something like that. Yeah, alternatives. So the judge is careful to make it as least restrictive as they can. And sometimes they let them retain the right to vote or even to drive, or it depends on case by case, obviously, on how that person is. We have them the whole gamut, don't we, Sandra? Of independent, living independent. Most of ours are in nursing homes, but we have a handful that are not. So, okay, another big question we get is who can file for conservatorship, and does that person have to be the conservator?
Anyone can file. Anyone from hospital administrator, nursing home administrator, relative, neighbor. Anybody has the right to file it. Typically, someone who is interested, that is concerned, knows something about it, is who you would see filing it. Because again, the conservatorship can be a daunting aspect for a layperson. How do I do that? Do I just go down to court and ask them? No, that doesn't work. There has to be a formal, sworn petition, and the statute has a laundry list of items that have to be listed in the petition. And part of it, as I mentioned, is the request to appoint a guardian ad litem. You typically submit a form order doing that with the petition so that the court chooses who the guardian ad litem will be. The person filing the petition can suggest someone as guardian ad litem, but the courts typically either formally or informally maintain a list of local attorneys who are both willing and capable of, and experienced in doing that. Because I'll tell you, a good guardian ad litem is really valuable in getting the process started. And the more thorough that investigation and report is, the easier it becomes for the conservator to step in and take over. And it's also a way to make sure that the respondent is being treated absolutely fairly. And that another aspect of what's required, family members have to be notified by the petitioner that this is going on. Children, siblings, whatever, parents, if there are parents, so that everybody has an opportunity to know what's going on and participate to the extent they want to. I mean, sometimes a hospital will file a petition and there may be a relative saying, well, I can do that. I want to take over for cousin John or my parent. What was the question?
It was his mom.
Yeah, anybody can file.
Except
Except the public guardian is prohibited from initiating the process.
That's right.
We'll let Rob talk.
Yeah. Did you want to say something about that? About, no, the public guardian not being able to file?
Yeah, I didn't want to,
You were going to say that?
yeah, I was going to jump around. I don't want to talk about the public guardian program specifically without actually going over it generally.
The whole thing.
First.
Yeah.
So I just kind of.
I was going to let you do that.
I'm waiting my turn.
Jump in any time. And really, if anybody has a question about any of these points, please just raise your hand.
Please.
It would help us to know what your thoughts or questions
There's
are.
one.
I come from I'm a prosecutor up in Campbell County. It's a very rural area. During our VAPIT meetings, there are a couple individuals that we keep getting referrals on who really have no family. They have people who are helping them, but they're not. They're taking advantage of them, and we've been trying to figure out how to go about filing for a conservatorship, which is what I'm hearing. But it sounds like the people that we would have to file the petition would either be me or the detective. But then I'm not certain about the cost and how. Have you ever seen that? I just don't know.
Well,
Thanks for.
yeah, I mean, first let me say that Chancellor Asbury is one of the best anywhere for dealing with these issues. You or the detective would have the authority to file it. Typically, the filing of it requires a cost bond, as with any litigation. And typically, or not typically, always, the petitioner is potentially at risk for paying court costs and fees, especially if the respondent has no significant assets or income. So there is a financial component to it. The court, on a pauper's oath, I suppose, could waive the court costs. But as we've kind of talked about, the process involves some expense. I mean, the guardian ad litem is entitled to a fee for his or her work. The petitioner's attorney is typically paid, not always, I guess. And in a case like that, it's almost predestined that the public guardian would be the appointed conservator, which of course would not necessarily entail any fees if there were no assets. So I don't know, I don't have a good answer for who to do that. There's really no one authorized, there's no program authorizing someone to be a petitioner that I'm aware of.
Unless, have you checked with legal aid?
No.
Because legal aid, I think that one would be of East Tennessee. I think that they do some conservatorship work. I'm not sure. Do you happen to know if legal aid does that? I don't know. Sandra says we get a lot of calls where legal aids told them to call us.
The ones we see that they end up in the hospital.
Right. So what happens a lot of times in those situations, they'll eventually end up in the hospital and the hospital will file for conservatorship.
I was also going to say that sometimes that, depending on the circumstances, APS can take over jurisdiction, and if APS has taken over,
They will not. They have routinely found one individual to be competent, and she's not she would fall under the vulnerable adult statute, and they have found that she does not qualify, much to the dismay of other parties involved.
well, in situations where they would qualify, the APS can take over, and they will submit petitions, and they will petition for the public guardian to serve as conservator in those circumstances. That does happen quite often.
Yeah, we actually have a really good relationship with our APS in all the 16 counties. I know a lot of people blast them, but we have a really good relationship with them. And then with the APS attorneys are really good and to work with for us. And I don't know, with the new self-neglect thing, that would probably screen out your people anyway from APS.
And that's the thing, is our investigator is wonderful, and she agrees with us, but it's not our investigator who makes the ultimate decision.
Right, of course, yeah. So, are they pretty elderly? Are they gonna end up in a hospital pretty soon anyway, or is
No.
it self-neglect? No.
So she is vulnerable as a result of a traumatic brain injury from being a victim of domestic violence.
Oh, gotcha.
And so she has somebody who helps her but doesn't. She's not fed. Her rent's not being paid. Her money's being spent elsewhere. She's on the street.
You also might want to try some pro bono attorneys, because according to Carolyn Gillum yesterday at the Ethics, that the Bar Association keeps the list. Oh, you're shaking your head if you already tried that, but you could try. UT's even pro bono program may help, but the Bar Association should have a list. Yeah, that one sounds like they could use it. Okay. Oh, we've got some more questions.
Go ahead.
Oh, well, and I just wanted to kind of piggyback off that because I'm with CREBA, so
Right.
we deal with elder abuse, and then we all know that form has a self-neglect concept with it as well. And we had a similar situation where we were actually able to go through legal services because we want to try to do the least restrictive means. And we tried to go the DPOA route. Well, when the attorney met with the client, she was like, "We cannot do this." Okay, so then it again ties my hands. He had no food. The bills weren't being paid. He had no one to get him to his doctor's appointments. We had scheduled multiple doctor's appointments with the van. He said nobody come and pick him up. He had to be very directed. You had to redirect him. He'd get really upset. He had some delusional type behaviors. And so at that point, it kind of tied all of our hands, and then we even set up a doctor's appointment, but there was no any type of transitional assistance because at this point we had him stabilized, but then it turned into self-neglect. And if the attorney won't write the DPOA and it doesn't meet the criteria for APS, even though we still know that there's some need there and he's not getting his needs met, what alternatives are there? Like, do we need to bring law enforcement in? Because he was on a vaping, he was in a referral for our vaping team. Do we need to reach out to law enforcement to say, hey, you can petition? Because I think that's been an issue too, is because I'm assuming they don't, or they don't know they can, and you've got the attorney fees. And what alternatives do we have? Because we feel like these are the people that are revolving doors for those referrals coming back through, and we're just ultimately trying to help them instead of putting Band-Aids on the situation. So that's my question. Once we've tried those least restrictive means.
Right. As far as whether law enforcement can actually petition, I don't know the answer to that as far as what their own policies are. There's no reason under the statute why they can't, but it might be their own.
And that's where we have
policy.
the problem is because we don't have anyone. They have no family, they have no relatives, they have no church members. I mean,
Right.
it's like. it's
So
like-
they're perfect for the
Yes.
public guardianship program, but we can't get them there.
Yes, absolutely.
Yeah, I understand. That's a problem. Teresa?
Are you all available for the public guardianship for someone who's vulnerable but not elderly, or is there a limit, an age limit?
Let's let Ryan answer that.
She got the question, but I slipped her. The program is designed for individuals that are 60 and older, but there is an exception for disabled individuals who are under 60, but it has to meet very specific requirements, and that's determined on a case-by-case basis.
So the Campbell County case might be one that would fit that.
Oh, are they under 60?
Yes.
Yeah, I mean, but in order for that to take place, there has to be an initial finding by a court. So it's still, even though they are under 60, they may meet the circumstances. There has to be a finding on the record by the court stating that these are the least intrusive means available, and also that they don't have any family, friends, any other entity, corporation, bank that's willing and able to serve. So once there's that finding in a court order, then a request can be submitted to TCAP for the public guardianship program.
Ryan, I'm Cheryl with Northwest Public Guardian. So can you give us the steps that we have to take for an underage? Because we have attorneys that say, when we say, well, you know, the statute says it's 60 and above. But when we do these underage ones, what do we have to do or send you exactly to get started on this? Do they just petition the court and then they send that to you guys with all the detailed information?
I mean, there needs to be an actual signed court order that makes those findings on the record.
Okay.
So that is the first step. And then we'll need the petition and the application and any other supporting documentation.
Can we send you like the application and the petition prior to it going into court and then send you the order after they sign it? But there again, the attorneys need to understand we're still legally not the conservator of that person that the court petitions until you guys approve it, correct?
Correct.
Yeah, and I think that's the biggest issue, is finding someone who would petition
Because of the cost.
because of the cost, and then they don't want to get involved. A lot of times, even if there is a family member, they're afraid to be involved, to be that one that does that, and it kind of makes it a difficult part.
The cost is what stops a lot of people, is you get these referrals, and then you explain to them how they have to go to file. And then they'll say, well, how much is this gonna cost? Well, I really can't tell you how much it's gonna cost. It all depends on if people object and how long it's in the court system. And then they'll say, well, I don't have any money. So I normally refer them to West Tennessee Legal Services. Sometimes it goes through, sometimes it doesn't, but, I mean, at this point, I don't have one under 60.
So Cheryl, does Northwest Legal Services today file for conservatorships for people, petition?
They do have a grant right now, is my understanding from talking to Elizabeth. They don't do it a lot, but they do it.
So you
It
might
just
wanna try
depends on
that,
the case,
because that's
though.
legal aid over there. The lady in the back has had her hand up.
So my background is long-term care, or at least that was my background before I switched to APS. So I've had many residents over the years complete advance directives, including the post form. But yet when they would go to the hospital, those weren't always necessarily honored. And my understanding is that if they have family members and the family member doesn't like the fact that mom is a DNR or doesn't want a feeding tube, and they can't say any longer what they want, I think that a lot of times physicians are terrified of litigation if they don't abide by what the family is saying when the resident cannot. But my question is, if someone has conservatorship And we're saying that all of their rights at that point have been assigned to this conservator, and they no longer have any rights to make decisions. If they've completed an advance directive, is the conservator legally bound to follow that person's wishes, or do they have the authority to override what that person once said, what they wanted or didn't want in their advanced care plan?
I'm gonna let Bill answer that, but I'll tell you from our standpoint, we never override their wishes if we can help it.
I think the technical answer is yes, if the order provides for that specifically. But I also think that what Lynette just said is the reality, that you want to be sensitive to the family's wishes and to common sense. But again, the conservator's authority is not absolute. It's limited, for example, that a conservator may not change the estate planning of a person, can't write a new will, can't change beneficiaries on life insurance or brokerage accounts, can't change the nature of joint bank accounts. Again, with the exception that unless the person needs that asset for their care. For example, let's say a person's got a big life insurance policy, the beneficiaries are their 3 children, but it has a cash value, that's the only asset they have. The conservator, again, can apply to the court formally with notice to these other interested beneficiaries and say, the respondent needs this money for their care, I need to cash this policy. And the court, of course, would listen to the children saying, but that's our inheritance. It's $1 million life insurance policy. She's going to cash it in for $600,000. What happens to us? And the court says, well, I don't know what happens to you, but your mom needs her money, and I'm going to approve it. Or the court says, no, there's another thing, sell the house. I mean, it's all fact intensive, which is a lawyer's way of saying I don't know the answer necessarily. But a conservator's authority over health care is pretty broad. But again, that has to be applied with common sense and courtesy or consideration for family members. And I suppose for religious custom too.
Any other questions? Yes, ma'am.
I know that I'm with APS, and I know that when we have filed for conservatorships, and for guardians even, we have to have a doctor's statement. Being faced with the fact that we can no longer do the self-neglect cases, that really reduced that. And we're trying to figure out how to help the public and family members and things, by telling them to file. But my question is, how do they get access to those medical records? Because we have access to that, but do they require that doctor's statement also to get a doctor on board? And how do you get access to that with HIPAA?
Well, the petition requires a sworn medical statement to support the allegation that the person is disabled. If the respondent refuses to go to the doctor, which is not uncommon, then the court can accept the petition and enter an order for an involuntary evaluation by a medical professional to determine whether or not the allegations of the petition about disability or incompetence are true. So that's one way around that. But again, it comes back to this question of who files the petition. And it's easy to say anybody can be the petitioner, but not anybody and not many people, or maybe no people, understand all the complexity and the risk of expense to do that. So maybe it calls out for a public petitioner, I don't know. There is, as far as I know, there is no institutional remedy for that. There's nobody out there saying, yeah, I'll file it. Because it's a very complex thing. And I mean, if somebody comes to you and says, my cousin Jimmy is dying in his house and nobody's helping him. Okay, you want to file a petition? Well, no, I can't afford it. I don't know him that well. There is a skepticism or reluctance. You're kind of invading their privacy. Somebody yesterday talked about that. Elderly people are very proud of their independence, of their finances. I mean, my mother, I'm a trustee for my mother-in-law. I don't know what she's got. She won't tell me. I mean, it's that, particularly people that are of the age that we're now seeing, they came through a lot, and they're very proud of what they've got. And most of them won't talk to their kids about it, at least in my experience. So there is a barrier there, it seems, that somebody needs to figure out. And in Campbell County, and I'd say Chancellor Asbury is very familiar with the under 60 procedure. There are 3 or 4 attorneys in Campbell County, without calling names, who are very good at this. And maybe one of them would agree to help pro bono for the lady you were talking about, to get it in court and get someone appointed. But it's, somebody's got to do it.
But along with that, they'll talk about what it takes to be the conservator, as far as you can't have any felony convictions.
Yeah.
And a lot of our people, we've had cases where we've had plenty of family, they all had felony convictions. So, that's what it calls to us.
Yeah, I mean, it seems like the remedy is there once you get to the point of asking for it. And it's finding a way to initiate the process that's sounding like the problem everybody see.
And another problem is no one wants to be conservator because they're afraid they're going to be held legally responsible for the actions of this person once they're the conservator. And so it's my understanding they're not. Is that correct?
I think that's correct. I mean,
I'm banking on that myself.
again, with the idea that you're in charge of their welfare, but if they escape from the memory care wing and steal a car and drive into a intersection at 60 miles an hour, you're not liable for that. And the conservator is also not liable for their bills. The conservator is not liable even for court costs, except by payment of the respondent's funds. I mean, it's a pass-through thing, but the conservator himself, herself, or itself is not specifically on the hook for these expenses.
And that brings up a point that a lot of times the procedures, the legal fees can be paid out of the assets of the proposed award. And so if you can find an attorney that would do it with that, it might be the way to go, right? Let me ask this question of you, Bill, before we go. Can a conservator live outside of the area, like out of state?
A conservator over the person, meaning medical and personal choices can, but a financial conservator needs to be a resident of the state. And as a practical matter, the conservator needs to be close at hand. I mean, that's again a practical, common sense thing. If you're going to take care of somebody, you need to be there to do it.
But a person that is someone's power of attorney, they don't have to be in the state, is that correct?
No, but again, common sense.
But by practical matters, they would be smarter if they were,
right.
yes.
And a lot of this stuff boils down ultimately to common sense, but there are also a lot of very technical requirements before you get to even thinking about common sense.
We have a case, for example, we got her through the CREVA program, but this lady her sister was power of attorney, but her sister lived in England. Then she had a sister that lived here in the same town as her, but she was the perpetrator, taking everything from her her. And so now we are her power of attorney, and her sister relinquished the power of attorney over in England. And it had been several years since she had even seen her sister, so she really didn't know what was going on.
We're gonna let Ryan finish up.
Okay.
Thank you. Again, my name is Ryan Hicks. I'm the Senior Associate Counsel with TCAD and also the State Public Guardian Coordinator. And what the Public Guardian Program is, this was statutorily enacted by the General Assembly, specifically for individuals that don't have the resources to pay for a private conservator, and they don't have any family, friends, or other entities that are willing and able to serve as conservator or the power of attorney. Because again, this is for the least intrusive means available, so to the extent that a power of attorney is an option, that's what will be done in those cases. It's primarily, like we were alluding to earlier, for individuals that are 60 and older, but there's an exception for under 60. So right now, we contract with all the area agencies on aging and disability to provide the public guardian services. And so there's 9 different programs across the state, and currently right now there are around 468 active clients in the program. And a large majority of those are conservatorship. About of those 468, 445 are conservatorships, and only 23 power of attorneys. And so most of the population they serve is the more elderly, disabled population that require conservatorship. The vast majority of them are residing in facilities. About 435 of them are in facilities, while only 33 are receive care like in the community, so like in their homes. And the under 60 population, there's only 26 currently enrolled across the state in the program. And so COVID has produced some very interesting trends. I'm looking at your numbers on that. It looks like ethanol is more of the exception to this, where prior to going back to the peak COVID, we had around 100 to 101 people that were receiving care in the community. It's because of everything, I assume because of everything that's going on with nursing facilities across the state. And once kind of COVID started trending back down, those numbers dropped off significantly. So from May 2020, there was 101 in the community. Going now, fast forward to this past May, there are only 33 clients residing in the community. So it's about a 7% drop. And so people are definitely moving out of the communities and back into the nursing facilities. And so that was a pretty interesting trend to kind of go back, because I've only been in this role a little over a year now, so I wasn't here for peak COVID and all the adjustments that had to be made on the fly. And so going back and looking backwards, it was very enlightening just to kind of look at these trends and look at all these numbers. And so that was the one that really like stuck out to me. Numbers, we are almost back to pre-COVID levels as far as the number of clients that are in the program. May 2020, there was 479, and we're up to 468. So we're just 11 off. It dropped down to May of 21, there was 422, so it dropped off probably about 50 plus individuals from the peak. So it stays consistent. The program is completely state funded through appropriations from TCAD, and you can also raise money locally. They accept volunteers. A lot of the volunteers will help do client visits. It's one of the requirements from the program is that the guardians that have to make monthly visits with all the clients, and so the volunteers can help make those visits while the district public guardian has to go out at least once a quarter. Got any things you want to? And we just. Well, I guess I have run us out of time.
Are there any more questions? Another question?
Is there an expiration date for conservatorship?
There you go.
Or expiration?
That's a good question.
You mean like a time limit? Only for an emergency conservatorship, which is one that can be put in place without all of these formalities being completed. And that has a 60-day expiration. But what typically happens there, normally happens if the person is truly disabled, is it's converted through another couple of hearings into a permanent conservatorship. So there is no time limit per se on a permanent conservatorship. But again, remember, it can be virtually anyone, including the respondent, can apply for termination if they feel it's no longer needed.
So it typically ends when the ward dies, or when the court decides they no longer need a conservator and it's transferred, or they're just set free, or We're out of time, but we're happy to stay here and answer more questions.
Yeah, I was gonna say, make sure you've got the sign-up sheet. Make sure you sign both the sign-up sheets. Any other questions? I know we started late, so we can go over a little bit if you want to stay.
But you're free to go, no shame.
What about somebody with mental health issues? Can somebody be granted a conservatorship over somebody who's not able to care for themselves due to their mental health issues, but then once they're, medically stabilized through medication, does the court then, take back the conservatorship? And then is it just an endless cycle if it's the individual doesn't want to take the medicine?
We've done that before. Someone gets stabilized and we assist them in going back to court and modifying or terminating the conservatorship, and they're free. Now, we haven't had that instance. You're talking about words and endless cycle. Sorry, I don't really have any knowledge of doing that. When ours are free, they're free. And we try to set them free as often as we can.
And one of the requirements for one of the other requirements for the public guardian program is, in relation to setting them free, is there the required ongoing duty for the program to constantly be seeking out other friends and family to serve as conservators for the individuals. So to the extent that they can find someone after they have been appointed, then they can transfer the conservatorship over. And also as part of the conservatorship process, annually the conservators are required to file a statement with the court saying that the conservatorship continues to be necessary. And that goes along with the annual accountings that have to be filed.
We're considered the agency of last resort, and so we tell everyone that wants to use us, we're the agency of last resort. You've got to show us where you've tried all these other family members first, and everyone you can find before us. Anybody else?
Any other questions? Great questions. Does everybody sign?
Thank you so much.
Thank you all so much.